Good evening. I'm Robert Klitzman, the director of the online and in-person master's and certificate programs of bioethics at Columbia University. And we're delighted to have you join us this evening for what should be a fascinating conversation. We're pleased to have David Hoffman as one of the speakers. He is a core faculty member in our Masters of Bioethics program here at Columbia. He is a healthcare attorney and clinical ethicist who's worked as a chief compliance officer and as a clinical ethicist at many hospitals in the New York area. He has also been the chair of the Committee on Bioethical Issues of the Association of the Bar of New York City. He's been a member of the Committee on Professional Ethics of the New York Bar Association and has been actively involved in both bioethics and law for over 20 years. We're also thrilled to have with us this evening Professor Carol Liebman. She is a clinical professor of law emerita here at Columbia University. She founded Columbia's mediation clinic and the negotiation workshop. She's an internationally recognized speaker and trainer in conflict resolution. And she also is a co-author with Nancy Dubler of Mediating Bioethics Disputes, a guide to shaping shared solutions, which is one of the seminal textbooks in the area. And we are deeply honored to have us with us this evening. So without further ado, David, welcome.
Thank you very much, Bob, and welcome everyone. We are thrilled to have you all here today. We are here for what will be a very interesting and frankly, somewhat disturbing review of where we stand in the middle of the pandemic situation, and specifically some of the challenges that have been presented by the fact that, frankly, we did not prepare as well for this pandemic as we should have, and not even as well as we could have. And that has led to, let me be frank, some pandemic panic. So today we're going to talk about the nature of that problem, the legal sort of foundation for the difficulties we're facing, and how mediation and de-escalation techniques can be useful to lawyers, clinicians, social workers, case managers, in order to get us through what we have been told is going to be a rather difficult next 3 to 6 months, after which things ought to get a lot better. And after I've given a brief introduction to the legal context, Carol Liebman is going to walk us through what mediation is and what mediation has to offer clinicians and institutional representatives as a way of dealing with some of the pandemic panic that we've had to deal with. So how did we get here? So to begin with, we got here because we did not react in time, and that's entirely our fault and an unfortunate reality. What we're dealing with now is a circumstance that, frankly, we thought was terrible back in the spring. This is an article from the New York Times in May, saying that the lockdown delays cost at least 36,000 lives. Now, of course, we're dealing with the reality of over 250,000 lives lost to the pandemic. And the unfortunate reality is that this was all entirely predictable. In fact, some of our colleagues at Columbia at the Mailman School of Public Health wrote this paper at the end of May, Differential Effects of Intervention Timing on COVID-19 Spread in the United States. And in this paper, they concluded that if the techniques that we now take for granted, wearing masks, social distancing, avoiding large gatherings, had been implemented just a couple of weeks sooner, there would have been a very significant reduction in the number of people who got sick and then ultimately died from COVID. So a valuable lesson learned. It was apparent almost immediately that we were in for some difficult times. This is another article from the New York Times talking about how nursing homes had become hotspots and how action taken by the government and by industry really exacerbated this situation to an extent that really wasn't necessary, but was not the least bit surprising, given that we dove into the pandemic without taking the steps that we could have implemented and learned from the prior experiences, Ebola and the swine flu and the avian flu, and that's a shame. But what came of that from the perspective of a legal response is some legislation, specifically the Emergency or Disaster Treatment Protection Act, which afforded a rather sweeping measure of immunity for all sorts of people, not just healthcare providers, but institutions and consultants and administrators, as the best reaction that the government could come up with in a hurry. This bill, for example, was passed as part of the annual budget bill at the beginning of April, in order to reassure clinicians and institutions that they would be able to take the steps necessary to deal with a pandemic, including the scarcity of human and physical resources and the need to make decisions about who should go on a ventilator and who should come off of a ventilator. And this was a really quite powerful law, one that ruffled a lot of feathers, and in fact led to that article I showed you a moment ago, where people were objecting to the fact that, particularly in the case of nursing homes, they were given this rather sweeping immunity. So let's take a closer look at this. This law said that retroactive to May 7th, immunity would be afforded, and that it shall not apply if the harm or damages were caused by an act or omission constituting willful or intentional criminal misconduct, gross negligence, reckless misconduct, or, and this is the important one, intentional infliction of harm by a healthcare facility. Now, the problem that was immediately presented by this characterization of the Emergency or Disaster Treatment Protection Act is that, of course, when you make a conscious decision to either withhold care or withdraw care, such as taking somebody off of a ventilator, that would clearly fit the definition of intentionally causing harm. There's nothing unintentional about a decision to take somebody off of a ventilator. So the law went on to further qualify that acts or omissions or decisions resulting from a resource or staffing shortage shall not be considered to be willful or intentional criminal conduct, gross negligence, recklessness, or intentional infliction of harm. So a grant of immunity, a limitation on anything that's intentional, but then a redefinition of intentional to carve out intentional decisions that result from either equipment or staffing shortages. Now, why did we have to go to this kind of law in such a hurry? Well, as I said a moment ago, it's because we didn't learn the lesson that was offered by the earlier pandemics that we have confronted, both from a clinical perspective and from an ethical perspective. And we learned these lessons. One example being the ventilator allocation guidelines that were promulgated in 2015 by the New York State Task Force on Life and the Law, which specifically said we need an emergency standard of care so that clinicians can know what they are allowed to do and not do, what care they're allowed to offer and then withdraw, and to be sure that they would not be charged, for example, with murder if they withdraw somebody from a ventilator and that withdrawal from the ventilator results in the patient dying. Well, so having not learned this lesson, facilities were left to their own devices, and sometimes those reactions were not, ethically speaking, up to the standards that we would like to see abided by. And so in long-term care facilities, which have been severely criticized through the course of this pandemic, a lot of people said they didn't respond well at all. And one case in point, very close to home, was the situation involving my father-in-law, who, with my mother-in-law at the time, before her passing, lived at an assisted living facility. And when he tested with a very, very mild temperature, he was immediately told that he had to go to the hospital, that he didn't have any choice, and that even though he had decisional capacity and had a healthcare agent appointed, my wife, Joan, his daughter, that he could not even consult with her. And in fact, the staff of the facility said to his private duty nurse, no, you cannot call the resident's daughter. We don't have time to talk to him. We have to get him to the hospital. And the private duty nurse, thank heavens, called us anyway. And we actually wound up, and it horrifies me to share this, in a shouting match from our cell phone at home to the cell phone of our private duty nurse, who had it on speaker and held it up to the staff of the facility, where we told them, you do not have permission to take our father-in-law to the hospital until somebody has explained what's going on here. And they refused. They said, we can't talk to you right now. We don't have to talk to you right now. And of course, as a legal matter, they were right. The Emergency or Disaster Treatment Protection Act said that they had no civil or criminal liability for any decisions that they made in relation to treating patients in a COVID pandemic situation. And that's a shame. So literally hours later, this communication went out to every resident and every family. And it said, very interestingly, let's take a closer look here. This was from the leadership of the facility. I want you to know that if a resident exhibits symptoms or registers a temperature over 99.6, our first step is to consult with the resident's family and physician. If the hospital or Department of Health orders the test, a COVID test, and the resident and family are in agreement, they are transported to the hospital. Very interesting, obviously very lawyerly choice of words. And this was, unbeknownst to almost anyone who isn't participating in this webinar tonight, this was a direct response by them to the shouting match that had occurred earlier in the day, when in fact they transported a patient to the hospital for a COVID test over the strenuous objection of the resident's family. So we see that hastily drafted and implemented laws can have serious negative effects, not the least of which are in the working relationship between residents and their families on the one hand, and the facilities on the other hand. So that was the cautionary tale. And then we went to the rapid succession of executive orders that we had to deal with, including this executive order 202.30. They all come out looking just like this, rather dramatic and very official looking, State of New York Executive Chamber. We are now, by the way, up to Executive Order 202.79, and then a series of other executive orders related to COVID. It's been a nonstop job just keeping track of what the changing rules are, legal, directives of the health department, guidance and health advisories from the health department that we'll talk about again in a few minutes. So this executive order was one of the first to create a serious burden and really the potential for conflict between residents at long-term care facilities, their families, and the institutions themselves. So let's take a closer look at Executive Order 202.30, and in particular, the provision that says any Article 28 hospital, that's any general hospital, is not allowed to discharge a patient until the patient has first had a COVID test and obtained a negative result. Now, what are the implications of that in terms of the rights of the institution and the obligations of families to respect the decisions of the institution? Well, for starters, it makes it very difficult for the hospital to manage the patient from a legal perspective, but at the same time, it creates the circumstance where the hospital is not allowed to send a patient home to a long-term care facility, an assisted living facility, for example, as a matter of law. But, and this is what was lost in the rush to promulgate all of these rules, that does not change the right of a patient or resident in a long-term care facility to sign themselves out of a hospital against medical advice and then just show up at the door of the assisted living facility, for example, which is, after all, that individual's home, and demand to be let in. Well, at the time that 202.30 was promulgated, we didn't have a good sense as to what we were supposed to do if a patient signed themselves out against medical advice. And even today, many months later, it is not clear at all how a hospital should deal with a patient who wants to leave, even in the absence of a negative test, and how a long-term care facility is supposed to treat that patient when they show up at the door. The interesting part, of course, is that the state, the governor's office, and the health department realized that patients have certain rights under laws, which we'll talk about in a few minutes, that make it difficult or impossible for an institution to turn someone away. And in fact, that has been the subject of another executive order that just came out the day before yesterday, so hot off the press, it didn't make it into our slides, but I'll talk about that later. So what you can see is a real tug of war between our obligations to respect patients' wishes and to respect the directives that are being handed down by the government in order to address the public health implications of COVID while we are busy addressing the larger set of issues that are presented at the patient care level. So I'm going to run through this rather quickly because the details aren't important. What is important is that we have, since March, seen a cascade of directives from the governor's office through the executive orders and the health department, including this health advisory, which doesn't have a legally enforceable authority in the first instance, because they are just advisories, but they set the standard of care that the state is creating for what institutions are obligated to do. So this May 11th directive, this is an actual, it's called a Dear Administrator letter, said that you are obligated to conform with the requirements of 202.30 and a whole series of other requirements. And they actually required that, as you see here, the operator or administrator must provide the Department of Health with a certification of compliance with Executive Order 202.30 and all other applicable directives of the Commissioner of Health, which means all of those health advisories and otherwise less legally authoritative directives now are an obligation which institutions are required to certify their compliance with. And one of them, of course, was a directive dated May 10th, except guess what? In haste, people make mistakes, all humans do, and the government is no different. There is, in fact, no May 10th directive from the Commissioner of Health. What there is a May 11th directive just from the health department itself, and that directive set the new set of standards that we're currently operating under which employees and other staff at long-term care facilities are obligated to be tested for COVID weekly, and a variety of other requirements, all of which create tension, conflict between the facility staff and the family and residents at those institutions. So, for example, this portion of the guidance says that no hospital shall discharge a patient to a nursing home or adult care facility unless the facility administrator has certified that they are able to provide that patient with adequate care. And this also reinforces the requirement of the earlier directive that there has to be a COVID test with a negative test result. But wait, it gets even more complicated. When we deal with a patient who wants to be discharged but can't be discharged because they haven't yet gotten a negative test result, we have the very real conflict between the public health imperative and the patient care imperative. So that is the fundamental, the existential dilemma that all long-term care facility administrators and clinicians face when they're trying to confront these kinds of situations. So then the health department said that with the exception of the obligation that hospitals have not to discharge patients who have not yet tested negative, a nursing home or adult care facility cannot deny admission of a resident based solely on a resident's COVID-19 diagnosis. And this is the circumstance back in the spring that caused hospitals to offload COVID positive patients into nursing homes. Now, remember earlier, there was a requirement that the facilities certified that they were able to take care of the patients. The reality is they weren't. Most long-term care facilities don't have the logistical capability of cohorting the patients and applying dedicated staff who would only take care of those patients so as to prevent the spread of COVID within long-term care facilities. And that, of course, is what led to all of the difficulties that we had early on that led to the passage of the Emergency or Disaster Treatment Protection Act. Which brings us to Thanksgiving just a few days ago. And there is our Governor Cuomo, getting a COVID test immediately after issuing further directives, guidance, requirements, health advisories, including this one. This is the November 24th. Yes, that is 2 days before Thanksgiving that we first got this health advisory that said that every long-term care facility had to tell every patient that if they left the facility for a family visit or any sort of a social interaction, take a closer look here. If a resident leaves for home or family visitation or a social outing, I'm still not sure what a social outing is in this context, but okay, let's use our imagination, that they are not allowed back until they have had a negative COVID test result within 24 hours. Now, here's the logistical complexity there. There are very few places outside of major urban centers where you can get a rapid COVID test and have the result supplied within 24 hours of a designated date for return to a facility. And that has created an impossible set of circumstances for the facilities and for the families, the net effect of which, and this is the unfortunate part, which we'll address in our role plays in a little while, the unfortunate reality is that that left the facilities in the awkward position of saying to the residents and to their family members, you know what? You really just shouldn't leave at all. And guess what? That's exactly what we did at long-term care facilities across the state. And why did we do this? Because we knew that residents would not be able to get a rapid test in every corner of the state, and that if they came back even with their rapid test, the logistical requirements of this directive, that is that these residents would have to be cohorted and kept in a separate part of the facility, and that they would have to be treated as if they were presumptively ill for 14 days, with all of the staff taking care of them having to wear personal protective equipment. So these are the requirements after somebody gets their negative test before returning to a long-term care facility. They have to be quarantined on transmission-based precautions for 14 days. They have to have tested negative immediately before, 24 hours, no more than 24 hours before. They then have to be tested 3 times during the 14-day period. And during all of that time, every staff member who comes in contact with one of these patients has to treat the patient as if they're COVID positive and therefore use full PPE, full exposure precautions, which presents the even more daunting problem of burning through our PPE supplies, which we need to take care of patients back at the hospital. So we were told that we had to develop a plan for the return of these residents, but we were also told that the requirements for that plan were quite literally unachievable. And then, as if that weren't enough, on November 25th, literally the afternoon before Thanksgiving, we got this further information regarding the holiday guidance that had come out the day before. This is in the form of an IHANS notification. That's the information sharing system used by the state health department, reminding the facilities that they had to remind the residents that it was going to be really tough to get back in. What was the effect of this? It was really this. The November 25th guidance was the subtle communication from the state health department. You just shouldn't let people leave the facility in the first place. And that's a really awkward position for the leadership of a long-term care facility to find themselves in. And that led to a lot of the problems that we're going to be talking about as needing mediation and de-escalation in the aftercare environment. Now, a very quick review of the laws that govern the behavior between facilities and residents of long-term care, nursing homes, and assisted living facilities, of which there are many. So 415.26 is the requirement that no nursing home is allowed to take a patient into their care unless they are able to represent that they can provide adequate support for that patient, which frankly, during COVID, most institutions just don't have the space or the staff to do to any standard of care that any of us would be happy with. There's a similar set of rules for patients in assisted living facilities. This is 10 NYCRR 1001.8. These are analogous to the patient bill of rights that we've had for many, many decades for hospitalized patients, but they are even more prescriptive and they create an even greater set of responsibilities at just the moment when the institutions really have very little control over, for example, a patient signing themselves out of a hospital against medical advice, or showing up at the doors to an assisted living facility or nursing home and saying, let me in, this is my home, I paid for my bed, I'm allowed to use it. Now, there are laws that enable us to keep patients in the hospital over their objection, 9.27 of the mental hygiene law, but that requires a finding that the patient is a danger to themselves or others, which begs the really uncomfortable question, is a patient who simply wants to get out of a hospital, a place that is in fact a danger to the patient because there are lots of patients with active COVID cases in most hospitals in New York, and wanting to go home, is that a danger that they present to themselves or others? I, frankly, as an ethicist, am not comfortable asserting this authority to deal with the uncomfortable situation that has been created both by the pandemic and by the very prescriptive regulations that have been handed down by the governor's office and the Department of Health. Another piece of law that heavily influences all of these decisions and frankly renders the need for a lot of the executive orders and health department directives as academic or moot is 405.9 of the minimum standards for hospitals, which requires that no hospital can ever discharge a patient without providing a safe discharge plan. So that obligation already existed. And frankly, if the governor's office had relied more on the existing law and provided more guidance on how to apply, for example, 405.9 to the situation faced in the pandemic, we would have had and would be having now much less conflict between facilities and the residents and families that the facilities serve. So if you find all of this technical legal discussion interesting, I would refer you to a program that we did, interestingly enough, back on May 21st. It was another legal education event with a substantial international perspective, the title of which was Response to COVID-19, Legal and Ethical Perspectives, and that can be accessed on the Columbia Bioethics website. And if you're interested in all of the sort of more legally technical and more public policy details about how we respond to legal and ethical challenges in COVID, I strongly urge that you check out that program from May 21st. because now we have to turn our attention to the solutions. And the solutions, as I mentioned earlier, can only come through enhanced technique for communication between facilities and the residents and families that they serve. And for that, I am going to turn you over to the capable hands of my friend and colleague, Carol Liebman, who is literally the authority on mediation of bioethical dilemmas. And so, Carol, I turn this over to you. Carol, you're muted, so just unmute yourself. We all make that mistake.
I just said that it's nice to be recognized as an authority, but where was that recognition when my kids were teenagers? So it's a pleasure to be here tonight. Pleasure is the wrong word when, after hearing David walk through this Alice in Wonderland regulatory world that we now live in, or you live in. The original plan when David asked me to join you was to spend a good bit of the evening talking about bioethics mediation, how it works, how you can use it in a kind of more leisurely, calm approach to conflict resolving. But as we talked over the last few weeks, it seemed pretty clear that what would be even more useful is to teach you or give you some information about some of the tricks that mediators use to try to resolve conflicts. Because I think the one thing that this barrage of regulations has guaranteed is that you're going to be in lots of conflict conversations, difficult conversations during this holiday season. And so I will spend a bit of time introducing you to the basic mediation, bioethics mediation concepts and structure. But leave any really deep exploration of that process to a more normal time when we can perhaps get together again. And I will spend a good bit of my time talking about some key conflict management tools. And then David and I are going to do a demonstration of how these tools might be used. I must say his description of the difficult conversation he had with his in-laws facility makes me really look forward to the role play we're going to do in a bit. So this is a basic definition of mediation, and I'm going to highlight a few aspects of this definition. First, that it's a process. David spoke about mediation helping you find solutions. Mediators don't worry about the solutions. Mediators worry about communication and about providing a setting where people can negotiate, can talk, can develop understanding, realizing that the solution, if it's there, will find itself if the process works. So one of the things I'm going to be suggesting to you throughout my segment of the program is focus more on communication and on understanding, and don't worry so much about fixing things. And that, for most of you, is totally contrary to how, whether you're a medical professional or a legal professional, our jobs are to figure out what's wrong and fix it. But when you're in a conflict situation or dealing with a really heated conversation, trying to fix the source of the conflict without taking time to talk about it and understand it is probably only going to make the conflict worse. So spend some time on process. Mediation really is a process where the mediator is not a judge, not an advisor, isn't a decision maker. A mediator is a facilitator, the person who tries to help everyone at the table understand their own needs, their own interests, and understand the goals and interests of the other parties at the table. It's a private, voluntary, informal process in the sense that compared to court, there aren't rules, there aren't people up at a podium, but it also has the advantage of providing a different form, a different setting and some formality to trying to deal with conversations and communications and that have not been going well, so that it's an informal process, but with some formality and some ritual involved. I want to highlight that there's some core principles of mediation that it's useful to keep in mind. One is it's based on the notion of self-determination, that the parties have the right, have the autonomy to make decisions for themselves. Decisions don't get made by any parental figure, judge figure, anyone other than the parties, and that the decision-making needs to be informed. And I think in the healthcare setting, and particularly in the bioethics setting, there are two kinds of information that need to get shared. One is the medical information, the condition of the patient, the treatment options, what's involved in those. But the other is information, expertise that the family brings to the table about the family member, about the patient's values, concerns, goals before they became ill, before they became incapable of speaking for themselves. And then finally, in classical mediation, the other core principle is confidentiality. In the bioethics setting, you can't promise, in a typical mediation, I would say, everything that's said here is confidential and I'm not going to report it to anyone else, and no one here can testify in court. In the bioethics setting, you can't make that promise because there are a lot of members of the treatment team who are not in the room, who need to understand not only what the agreement is, but the rationale behind any kind of agreement that's reached. But the notion still that it's a private process and is an important one to keep in mind. Now, when people are angry, and I was we should envision David's conversation with the facility about his father-in-law. When people are upset and angry, the way they tend to communicate is through positions. You can't move him. And through insults. I'm sure David didn't insult the people, but insults. You've always been an idiot. You've always been uncaring. You people are so rigid. Generalities. This place is always doing this, and threats. I'm going to talk to the licensing people. I'm going to sue you. I'm going to get you outside. I'll meet you outside on the street. That's how people, particularly in New York, tend to communicate when they're upset. As a conflict resolver, whether you're the target of the insults and the threats and the generalities and the positional demands, or in the easier role of being a neutral, what you're listening for, even while you're having your stomach churn in response to an assaultive statement, what you're really looking for, and this is what I want to encourage you in the midst of the horrible, difficult conversations that you must be swamped with right now. I want to encourage you to somehow, when you're hearing all these kind of attacking statements, reframe them in your head and hear, what are the interests? What are their real concerns? What are they really after here? How are they feeling? What are the concrete things we have to negotiate about and resolve, and possibly even proposals? Often people, when they're the angriest, make proposals when they don't even know that they're making proposals. So mediators listen for feelings, for interest, for the issues. We're going to get some understanding of what the values are, and also the visions, the hopes of the people at the table. Now, in bioethics mediation, and I'm just going to run through this very quickly to give you a sense of what might happen in bioethics mediation. I thought about kind of presenting a sample case, and then I realized that would take up all of the time we have. So I just want to highlight that typically a mediator will, in a bioethics context, will get a call about a problem, talk to the person a bit about who calls with a referral, possibly check the medical records, stop by the patient's room, meet the family briefly, say hello, and meet before the sort of sit down with the family, meet with the members of the care team, both to get their sense of the situation and to be sure they're on the same page. Or if there's dissent within the team, if there are disagreements about whether aggressive treatment should be tried or not, to have the team reach agreement about how that difference is going to be presented to the family. Mediator would then get everybody together, the family members, the members of the team who decide that they should be there. And the mediator first introduces herself, explains her role, that she's neutral, that she's there to help people when they're having to work together to come up with the best plan of treatment, plan of care for the patient. That the mediator is not a judge, does not have any responsibility for the care, but is really there to help as a facilitator. Typically, even though probably everyone in the room knows each other, maybe they do, you know, there are always these assumptions made about people understanding everyone's role. So having a round of introductions and then turning to the family and having the family have a chance to, you know, tell me about Mama. What was she like before she got sick? What did she care about? Let the family, started means sit, tell me about Mama, admire the family for caring so much, and then discuss options and then reach agreement. But that tell me about Mama, it does a couple of things. It makes it clear to everyone, including the family, that their voice is important. It honors their expertise as the people who really know the patient the best. And it begins to level this playing field that in the healthcare setting is so uneven, with the patient and families kind of being visitors in an arena that people with different expertise and more expertise and long time presence have. So it starts to level that playing field. Typically then the mediator would turn to one of the physicians and ask for the medical facts. That is, what is the current situation for the patient? You know, and often that's often a time when it becomes clear that everyone has been talking around the fact that Mama is dying. So figuring out a way that you can encourage to support the healthcare team in making clear what they may have, each one may have thought that someone else has really sat down and told the family what's going on. So this may be actually the first time that the family hears, you know, in an organized and complete way exactly how dire a situation may be. Mediator then asks the other people, social workers, nurses, anyone else who hasn't had a chance to speak, to contribute their insights, their concerns, and then move into discussion of options and prognosis, hopefully reaching a resolution. Not always able to reach a resolution in mediation, but often can help narrow and clarify what are the real issues that are separating people. And as my colleague Nancy Dougler says, it usually doesn't make things worse. So there are a lot of settings where in the healthcare arena, particularly in the bioethics arena, where a mediator can help. You know, one is where the family is seeming to act against the best interest of the patient, or where the healthcare proxy is disregarding the express wishes of the patient, where the family just seems stuck on being angry and unable to move forward and work with the team, where the resident patient is making poor decisions for him or herself or theirself, where there's disagreement within the staff about what should happen next, about whether to be more aggressive, less aggressive, or where the communications between the facility and the family are repeatedly unproductive. These are all times that it might be helpful to bring in someone from outside, if not from outside the institution, from outside the immediate caregiving group, to help sit down and try to communicate better. So that's a kind of very, very fast run through of what's involved in bioethics mediation. And, you know, any of you who are familiar with mediation in other contexts, as awesome as the problems are that are dealt with in bioethics mediation, I've always thought there's one great advantage over all other forms of mediation, and that's that everyone in the room has a common interest, and that's doing the best they can for the patient. And so that common interest always can be a way to refocus. And even though people at the table may see different ways to fulfill that interest, the reminding everyone that is why everyone is at the table, and that's why the dispute can be so heated, because people do care so much, is a very powerful tool. So if you have questions about the processes, are awfully fast run through, but at least I want you to know it's out there, and maybe we can explore it in more detail at another time. But what I wanted to do now was turn to tools that may be useful as you deal with the holiday cascade of regulations. So I think the key tool that I'd like to have you think about, work with today, and is being able to, in the face of a positional statement, understand what the underlying interest is. So a position is a demand, an assertion. So landlord to tenant, if you don't pay the rent by the end of the week, you're out of here. It's got a threat in it, and it's got a demand. But underlying that very aggressive statement, you want to hear, what are the interests? Why is the landlord talking like that? Why are they making that demand? It could be needs money. They need money themselves to pay for the mortgage, to pay for their own home expenses, pay for holiday gifts for the family, who knows? It may be an interest in not being taken advantage of. It may be that not paying on time is seen as disrespectful, and that there's an interest in the tenant showing respect. So always when you're listening in a conflict situation to these positional statements, you want to be trying at the same time with another part of your brain to be thinking, what's really the driving force here? What does this person really need? What are they really upset about? So let me give you another example. So imagine here a parent. Sometimes I like to act this out with a colleague, and I always like to be the child. But let's say here we got a parent saying, you know, you're so selfish. You stay out for hours, and you're always out after curfew. You don't care how worried I am. You're not so smart. You're only 14, and I still set the rules. And the kid responds, you don't know what year it is. You act like I'm a baby. Well, I'm not. I can take care of myself. Stop hanging on to me. Well, forget it. I'll do what you want. Okay? So take a minute and just think. If you're typically in your real life in the parent role, think for a minute what the child's interest might be. If you're typically, or maybe for your whole life in the child role, think for a minute what the parent's interest might be here. I'll just give you about 30 seconds to think about that.
It's an interesting framing of a dilemma that we've all faced either in our child role or in our parent role.
Right. Okay. So positions again, mother, be home on time, do what I say, don't talk to me, and daughter, leave me alone, stop treating me like a baby, stop yelling. Not very helpful for working out a solution. But if you listen to them carefully, what do you imagine the mother's interests were? The daughter's safety, her health, getting enough sleep, teaching her to keep commitments, minimize her own anxiety, respect. And you can imagine the list going on and on. And the daughter may want to just have fun, have a social life, care about her reputation with her friends, want independence, some recognition she's growing older, get out of the house, respect, trust. And notice the respect is a common interest. So I don't know any mothers or daughters, any parent or child who could actually do what I'm about to suggest, but if you were a really savvy kid, you might say, Mom, I hear you're really worried about my safety, and I really appreciate that you think it's important to follow rules and follow through on commitments, and I don't really want to upset you, but I'm concerned about wanting to also be with my friends and be able to do the same things my friends do. And, I am getting older, and I need to have fewer rules and more respect for my independence. Now, I don't know a single kid who could do that. If they did, they'd wipe out every parent who ever lived. But when you're in the conflict situation, somehow you want to try to be hearing what's really going on here. And it may be just taking a breath and saying, let me see if I get what you're saying. I hear you. Or Mom, parents transparently say, I hear that you really feel that when I set these rules, I'm not respecting the fact that you're growing older, and I'm not, but I'm worried that. But indicating understanding, not just saying I get it, but demonstrating that you get it by summarizing what the interests are and what the feelings are, can really work magic transformations in difficult conversations. So I'm not going to read this slide, but you will have it for later, just some ways you can acknowledge interest. Again, you don't want to say, so you're worried about her safety. You want to say, it sounds like, because it gives you, it says, I think I get it, but correct me if I'm wrong. So if you say you're worried, you're telling somebody. If you say it sounds like, it says I'm trying to understand. And then the other thing you want to do is acknowledge the interest, and then you want to ask for information. But it's a very different kind of information gathering than most of us do as professionals. Most of us as professionals know the range of possible solutions, and we try to get information that will tell us which of those solutions is the right one in this situation. When you're in the conflict resolver mode or the mediator mode, you really are trying to ask questions that clarify your own understanding, the speaker's understanding, and if there's a third party involved, that third party's understanding what's going on. So you're asking open questions. Tell me about, help me understand, tell me more about, where are you coming from when you say. You're not trying to ask, gather information that will let you win the argument. You're trying to gather information that will let you understand the other person's perspective so that you can be in a better position to summarize and reflect their interests.
If I can interrupt for just a moment, Carol, for those of you in the audience who are going to be seeking CLE credit, we will have 2 participation codes, one now and one at the end of the program. So the first participation code is patient. So jot that down, and you'll be receiving an email form where you can fill in the 2 participation codes to earn your CLE credit. Back to you, Carol.
Okay, so some of the questions that may be helpful. And again, this not questions to prove, not questions to win, but questions to understand. Why is that important? Help me understand what's more important to you. What other things? What else might we do here? What options do you see? And then having listened, identified interest, ask some questions to clarify, and listen for acknowledged feelings. And I think feelings are the most important facts in difficult conversations. As I'm saying, I hear you're upset, I hear you're disappointed, I hear you're really worried about your daughter, I hear, kid, that you're feeling really confined or restrained. Acknowledging feelings is very powerful. But then when you summarize it, when you put it all together and summarize it, it was a colleague at Columbia said, summarizing is your it's your magic tool. It really is a way to let people know that you really get it and you're really listening. And so often, and I think that's the other thing that we see over and over again. I think particularly in a funny way during this crisis where there aren't any solutions. But I think people, you can't solve the problems. You can't make the virus go away. You can't make the regulations be more permissive. You can't make it safer to do away with regulations. But what you can do is let people know that you really do hear and understand why they're so upset. You're not judging them for it. You're not trying to change their minds. You're just accepting it and acknowledging it. And that somehow, I think I've heard lots of situations around the university where that's what people have needed. They needed to be heard and understood, and then they can let go and comply with what otherwise would seem like impossibly unfair rules and situations. So use your magic tool of summarizing.
Yeah, in fact, Carol, I often, when I'm involved in a bioethics consultation, I will say to the family member or the patient who is in a dispute, I really want to understand and make sure I understand what you're saying. Would you mind if I repeat back to you what I just heard? And by asking permission, you're sort of getting them to invite you to summarize what they've had to say. And I've found that that's a very useful technique, especially when you're in a very high pressured environment.
I think that's, I always like the idea that you are empowering the people you're working with and respecting them. The only hesitation I have there, I often will in my introduction about my role when I describe the process. So we're going to hear from the family, we're going to hear from the medical team. I'm going to ask some questions. I'll try to occasionally summarize. I'll kind of state that is what I'm going to do. My only hesitation about asking, is that okay, is of course never ask a question if you're not prepared to take the yes and the no. So there's some families and some institution administrators who I would not give that option. So, but I think in general, the point of empowering the people you're working with by giving them that choice and showing that respect is a good idea. Okay, so
that's a very good point, and it really speaks to some of the questions that we're getting into the chat, and I promise we will get to all of the questions after we do our role play. But the point is, there's a difference between a bioethics consultation in a clinical situation and mediation of that same dilemma. And oftentimes we resort to mediation when simple consultation doesn't work. But a lot of the techniques of mediation can be adapted to a simple consultation so that you're doing the things that you need to do, and frankly, with the hope that you can avoid having to get into a more protracted interaction that would involve bringing in either an internal or an external mediator. So that's often kind of the goal.
No, I think you're absolutely right that I mean, I think there's been a huge evolution. So I am a mediator. I am not an ethicist. I have been well trained by a number of ethicists, Nancy Dugler, Tia Powell, and all the great students in our courses over the years. But I'm a mediator. But my sense is over the years that the notion of the consult has evolved. And so it used to be, ask us and we will tell you the rules and play the judge. And I think there's much more a blending of the old model of consult and the mediation approach. And I'm one who says, use all the tools to solve the problem. And if you can avoid, if you go to a mediation, it's a big deal. It's a bigger deal than if you're just having a conversation. But sometimes making it a bigger deal is what the families need to know, that you get that it is a big deal for them in a different way than it is for everyone else.
Which is in fact a perfect introduction to our first role play. So you want to bring that up and we will lay the ground rules or context rather, and we can sort of demonstrate how these things actually play out in one of the COVID panic reaction situations that we're dealing with right now. So,
okay, so what here's what we're going to do here is we've got the situation, right? Daughter, son-in-law,
yep.
Of a resident and the nurse are had a conversation. This is the nurse Hoffman, and tried to explain the rules, and it didn't go so well. And so I have gotten a call from Nurse Hoffman, and Nurse Hoffman is playing a character. It's over. This is not how David Hoffman would handle this. He is perhaps drawing inspiration from some of the conversations he's had in the last few weeks, but he's going to now call me up and tell me about this disaster of a conversation.
So, hi, Carol. Thanks for taking my call. This has been, let me tell you, a hell of a week. We've got these rules coming out of every corner. I keep getting calls from the hospital's inside counsel, from the hospital's outside counsel. I, spoke to our bioethics consultant, but these families are really angry. And what I've been trying to do, because, we just don't have a lot of time, I've been trying to explain to them, it's not us. If you're angry, blame the governor. blame the health commissioner. Not that they're bad people, but they've really gone kind of overboard with all of their rules, and we're just stuck enforcing them. So I tried to explain to them that, yeah, there's a procedure. It's in these executive orders and these directives of the health commissioner that they're allowed to take their mother out of the facility for a family visit for the holidays, but that it's really actually not an option. The rules look like they create that possibility, but really what the rules say is it's impossible to come back. So, I mean, how am I supposed to convince them that they just shouldn't plan to take mama out of her assisted living facility, but if they do, they should not plan on being able to get her back in, maybe not for a very long time, and it's their responsibility, it's on them to figure out what they're going to do with mama for a few weeks or a few months. I can't take that responsibility. I've got patients coming out of my ears. Thank you for listening.
So, David, it sounds like this has really been a nightmare of a week or two with changing rules, different people telling you different things, outside, inside, and then when you actually have to turn to the families, there's not much you can tell them that's good. And that in a way you have to prepare them for the worst case, which is having their loved one homeless in effect for some period of time.
Yeah, and it's been these rules since March, but they've just gotten worse as people have no longer been able to do their socializing outdoors, and it's the holidays, and I can't even begin to imagine what it's going to be like trying to take care of all these patients when it gets closer to Christmas. I mean, Thanksgiving was bad, Christmas is going to be worse. What do I do? So
it sounds like you really feel overwhelmed by everything that's, you've been going full speed up till now, and now it's going to be even worse, both in terms of the health threat and the familial holiday pressures. I mean, holidays are always fraught and difficult and emotional, and they're going to be even more so.
Yeah, whatever comes after overwhelmed, that's where we are.
Yeah.
It's no fun being a healthcare provider now. Not at all.
So how do you approach the conversations with the family? Have you had any conversations yet?
Oh, I've had so many conversations. Every family is calling. The residents are saying, when is my daughter or my son coming to pick me up? And I tell them, look, we have all these rules that have just literally come out the day before or the day before that say, yeah, technically you're allowed to, and technically there's a process for you getting tested and coming back. But I tell them, we're really not set up to do all of the things that the government said we have to do if you come back. And that's if you're even able to get a test that can be conducted and get the result, and then you get back to the front door here within 24 hours. We don't know what to do. So I've been telling them, you know what? Don't leave. And if you do leave, I have to warn you, you're going to be on your own.
And how do they react?
Badly, because everyone's tired. And I understand that, these families and these residents that we have been dealing with all of this isolation and social distancing since March, but they're angry. And they're literally shaking the piece of paper in my face saying, this says the governor said it's okay for me to take mama home. Why are you being such a pain?
So it strikes me that there are a few things that you could do that might help. Not sure, because, but it strikes me as you describe how you approach this, like you've gone in with a lot of information, and some families may want all the information. But I wonder about what you said about the families have had to put up with the lack of visit and whatever, that might be a useful way to approach it, to start your conversation. To say, I got some really tough stuff I've got to go over with you. And I know I know that the last months have been so difficult, where you haven't been able to visit for long periods, where all these, spill out what you realize they've been through. And I know how much Thanksgiving, Christmas, the holidays being together, your father has been talking about how much he hopes he gets to be with you, how much you must, the thought that you are going to have to disappoint him, can't be with him, particularly when he's this old, this kind of condition must be so difficult. And then just stop and see what they say.
So how long do I stop? And what if they just say, can I take them now? Because that's kind of what I'm worried about.
Okay, so what would you say?
I'd like to say, call the governor, but I know that's not a good solution, right?
So how about asking him, saying, when you tell what's important to you, when you say you want to take him right now,
Mm-hmm.
and what are your expectations? What are your hopes for this visit if you take him?
Yeah, I really want the families to understand the health risks that they're subjecting their mother or father to.
Start to ask them what their hopes are, what their chance to be together, whatever it is. And then you could say, how do you factor in the health risks?
And should I ask them what they understand about the health risks?
That's always a tricky one, I think, in this setting. The families. You don't want somebody, you're not going to ask that question if this is somebody who's been telling you that it's all a left-wing conspiracy from the get-go, right? Then you're not going to ask them that question. But if it's a fairly informed family who has been sensitive, letting them remind themselves is more likely to have an impact. Then you can say, yeah, it's so, then you can say yes. And it's just so helpful to have families, family members like you who understand what's going on and what the needs. So you do what we call stroking.
I was going to say, it sounds like you wanted me to butter them up.
Want to validate them for being who they are. People like to be recognized. And it's to have families who care so much and who also understand what the problems are that we're dealing with is so helpful. So I think slowing it down and not trying to get to the end. You talked before about, I want to get them to understand that they shouldn't take the person.
Right.
Probably, but if that's where you're going, if you're spending your energy there, you're going to be just battling. You need to let them get there themselves, if possible, and if not, in the end. And then you can say, I hear you want and you understand, and let me tell you what we're up against. And the choice should be, but it's not the choice because of the regulations. And these aren't the regulations I'd write. I'm sure they're not the ones you write, but the regulations are, but after you've shown some understanding for the family, appreciated them, let them talk about what their hopes and goals are, so that it's not just you coming in and saying, too bad, can't take grandpa, and here are all the rules, and I'm going to keep telling you what all the rules are. And I mean, that makes people feel like they've just had a stamp put on their forehead. So
yeah, that clearly has not been working.
Yeah, letting them talk about what their hopes are, what their understanding of the healthcare situation is, if they understand it, if they don't seem to understand it. You may have heard this again, but let me just, and then I wish I could say yes. I wish that if it were in my power. But let me play out for you and what is going to likely happen.
So, Carol, do you think it would be helpful if I tried to get them to understand why the governor made these rules in the first place? I mean, should I be treating this as a teachable moment? I feel like I want to, but I also feel like they're not interested. This is, in fact, for them, not such a good teachable moment, but it's a moment where they need to understand what we're all up against. I want them to understand that I'm on their side.
Right.
but I have these obstacles.
So when I was still teaching in the mediation clinic at Columbia, we would do a lot of neighborhood disputes, and a huge proportion were noisy neighbors. And they would get, they'd either to face each other's doors or get in physical confrontations. And the way we almost always solved those was we made the building the common enemy. And so in a way that can be an advantage. You have a common enemy in a way, but in a way, I think it's useful to say we're on the same side.
Mm-hmm.
But in a way, it doesn't help, I think, to demonize people who are doing the best that they can. And
right. I'm not angry at the governor. I'm not angry at the health commissioner. I understand that they have public health responsibilities.
If I were running, yeah, I mean, so see, now you've made the progress from being angry when you were, this is out of roll. Notice,
feeling better.
Notice that now David has moved from the governor and the, he put the thing up his nose, and that's not the only place he'd like the governor to put it, to I understand their obligations, they're doing their best. So it's in a way, it's a mini a demonstration of how you'd like the process to go with the families. But it's
that's what I'm working toward.
Let them set I guess what I'm saying is let them set the agenda. And then figure it out, and offer. I mean, you talked before about saying, is it okay if I summarize?
Mm-hmm.
Would it be helpful for me to run through the regulations? Would it be helpful for me to kind of spell out for you in detail what quarantine in a place like this is going to look like?
Yeah, I can tell you,
I think the other thing you have to remember is I think everybody feels so under control right now that anything you can do to let them have some choice, whether it's yes, I want to know about the regs, or no, I don't. Mm-hmm. Yes, I'd like, please describe it to me again, or please don't, about the quarantine, what quarantine it looks like here. Lets them have a little sense of power over the situation. And I think that's another thing that you can do in these kind of conversations, is just letting them choose what to talk about, what would be helpful. We could talk, you could say at the beginning, we could talk about what the requirements are. We could talk about what it'd be like to come back, how this happened. We can take the mega philosophic, what's happening in this world that we have these regulations that come out 2 days before Thanksgiving. What would be helpful to talk about? But just giving up the control rather than trying to sell them on, convince them to do X.
I can tell you, as I talk to my doctors and nurses and other clinicians about the challenges we face in doing what's legally required, doing what's medically the right thing to do, being respectful of people's needs in what has been just a very, very long slog. All the while, trying to figure out a way to talk to people that is respectful, but doesn't give them the hope that if they keep at it long enough, that somehow they're going to win. So there's a there's a certain measure of frustration in the patient care community about this being kind of hopeless, specifically because everyone is trying to wear the other side down. And to your point earlier, right, the only common enemy, and the governor made this point at his press conference on Tuesday, the common enemy is the virus, right? And I wonder sometimes if we can do a better job of making the virus the bad guy.
Yeah. I think going back to that over and over again, I hear that you wish, if it were my power, to let you, to say yes, but as long as the virus is around, I'm not sure. That's not something I would feel comfortable saying, even if we didn't have the regulations.
Let's touch. Go ahead. I'm sorry.
No, go. I think the virus really is the enemy, and that's the thing that we have to keep remembering. And then people are imperfect, and I think just sort of saying people are imperfect. They're doing the best. If you get in a fight about that, so I think this is more likely to happen when you, as lawyer, are talking to your client, the facilities, and you know, they're doing the best they can. I mean, that's how we started this conversation 2 weeks ago. Who are these people and what are they doing? But they've been doing it nonstop for like the healthcare people, the regulators have been doing this, and the planners have been doing this nonstop since March.
So one of the observations that I've made over the course of the last 9 months is that because people are worn down, because, you know, we've been in this fight flight mode for such a long period of time, and everyone is suffering from COVID fatigue and family fatigue and dealing with finding ways of having something approaching a normal social life, family social life, friends social life, outdoors, and now all of a sudden outdoors isn't an option, right? It's gotten cold and it's going to get much colder. I feel like for some of these families, they really are at the end of their ropes, and the informal problem solving and de-escalation techniques that we've been talking about are not going to work a lot of the time. So can you talk just for a few minutes about what actual mediation would look like in these situations, and how you sort of entice the two sides to a dispute into mediation when one side is a family that is very, very concerned about their loved one, and on the other side you have an institution that is very concerned about its clinical responsibility, its compliance with all of these laws and regulations. How do we bring people into a more formal mediation discussion?
Well, I saw that Bob Kleisman also asked, how can we use these techniques to solve the national divide, which is in a way, so, you know, I've thought a lot about, not so much in this context as in the political context. Actually, for a long time, I didn't even want to think about it. I was so stressed and angry, but I've been thinking more since the election about what are the ways we get people talking with each other rather than at each other. And, you know, a formal mediation, maybe institutions have some sort of internal process with, you know, somebody in the, normally you'd want the mediator to be from in a formal dispute, normally in the North American, Northern European cultures. So this is all very culture bound. The mediator would not be anybody who had any ties to the parties. Because you're supposed to be impartial, or neutral and impartial are used. I don't think we're ever neutral. We can be impartial in the sense that we can be on both people's sides, you're not being for one over the other. But you might want to try a kind of, it's not so different from family meetings, you know, case planning meetings where somebody acts as a facilitator. You may want to identify one or two people within the institution who are just good communicators, good facilitators, and have them available to help with the conversations. I know in some of the work I've done about disclosure of medical error, one of the things that became clear is that some fabulous physicians are not the best communicators, particularly when their professional performance is under attack. And so if there was going to be a disclosure or discussion about something that went wrong, it was important to have somebody, not an outside mediator, but to have somebody who had the mediator's skill set to help with the conversation and kind of act as a in the moment coach, step in. So I think that's probably, it's using the mediative approach to these conversations rather than bringing in a mediator is what I would suggest.
I have found, and this is something that clearly within the healthcare delivery system we need to develop further, just having a mechanism for bringing a new face into a dispute, either between clinicians or between clinicians and a family or a patient or resident. That new face can be somebody from the institution, it can be somebody from a neighboring institution, just giving the family a chance to talk about the treating doctor or the nurse or whomever it is that they have the dispute with that individual not in the room, so that there's somebody that the family can speak to and somebody that the clinician, the doctor, can speak to get their position out on the table, to sort of offload it, kind of the way I did at the beginning of our role play. You need somebody to talk to who will listen and who you don't perceive as being opposed to what you're trying to say. I think that in these kinds of COVID panic reaction disputes is probably the most useful role that somebody in the function of a neutral, right, which is the way we often refer to mediators. That person who's acting as
doesn't have decision-making
right
responsibility. But it's interesting in formal mediations now, and big high-end commercial mediations, there's more and more move toward having the mediator have individual meetings with each side before they get into the initial mediation session, as a way of letting people kind of, in a way, get some of the stuff off their chest, so that they're closer, they feel they're not as suspicious of the process, and then they feel safer to sit down and talk. I think everybody needs support here, and the families and the physician, and when you had interactions over months, years, that haven't been terrific or have been going downhill in the midst of the crisis, having that outside person come in and ask people to spell out. We tend to start talking shorthand, and having somebody from the outside come in and say, well, I'm not sure, you said X, can you tell me a little bit more? What do you mean?
Mm-hmm.
When you say that they always, your doctor is always on, give me some examples. Like they're always making noise upstairs. Well, when was the last time? Well, 2 weeks ago, and then last summer. So all just getting people, asking the party, somebody who can ask those questions, and it's so somebody who isn't a party to the ongoing miscommunicate or malcommunications, rather than miscommunication, it's bad communication.
Right.
Okay.
So I think the take-home lesson from this conversation for our participants is, in any dispute that a clinician is having with a patient or family, a fresh face, someone who, even if they're not formally in the role of a mediator, and even if they are not in fact disinterested, if they can serve as that other set of ears that the family can express itself to, and where the person listening and feeding the follow-up questions, engaging in all of the different techniques we have, reflective listening, and bringing the family or the resident into the dilemma that the institution faces, and then the converse also, having someone for the clinician to talk to about their frustration with the family, where the family isn't there getting defensive about it. These are what I have found to be the most useful de-escalation techniques in all of the years I've been dealing with families who are unhappy with a diagnosis or the unavailability of a certain treatment. So, these skills all have a place.
And notice what you really described is somebody who can be a non-judgmental listener.
Right. Yep.
Yeah. And when you're trying to get something from somebody, or get them to let you do something, or get them to do what you want, you're also judging, and people pick up on that pretty quickly. I'm thinking, we've got people from throughout the state. There are community dispute resolution centers throughout the state. And if you go to the Office of Court Administration webpage and look for mediation, you can find the nearest center. And it might be interesting, maybe not right now, but if there's ever time to come up for air, to talk to the centers about doing some training for staff.
Yeah, no, I think that's
having a team of local facilities get together and send some key staff to do some just even to go through the mediation training.
We have clearly learned that we need to, in healthcare facilities, both acute care and long-term care, we need to be able to deal with these situations more effectively. And look, even with the vaccine literally on the horizon, we're probably still looking at another year before enough people have gotten the vaccine that the living situation of the entire community has improved, for sure.
And the conversation I keep imagining is you're a hospital, you're a nursing home, assisted living, and the list comes out of who gets priority. And is it going to be the housekeepers who say, wait a minute, how come the kitchen workers got it? The kitchen workers say, how come the chefs got it? And the dish, you're going to have one of those, not everyone isn't going to get it at the same time. And the distinctions aren't going to seem fair or rational if you're
That's
somebody
for sure.
And I think, again, just being able to not try to convince people, but try to hear people that it doesn't seem fair. You're really worried. You feel like you're just as exposed. And I'm not saying you're not. We're stuck with these rules, and I wish I could do something about it. But
and we are, in fact,
not trying to change their view, but just acknowledging their feelings and acknowledging why they're concerned. I think
that list
very important.
That list will actually be coming out, we think, maybe as soon as next Wednesday. And you're right, that's going to create a whole new set of tensions and disputes that will need to be managed and de-escalated. So I think let's jump to some of our questions, because they sort of start with the legal foundation that I introduced at the beginning, and then move into more of the problem-solving techniques. So the first question had to do with how the law put us in this situation in the first place. Was it erroneously conceived because it was hastily drafted, or did the legislature deliberately provide an enormous amount of immunity from liability? And I think it is clearly the latter. Having missed the opportunity to create an emergency standard of care so that people could be guided and understand what they needed to do, all the legislature and the governor's office could come up with was to give the clinicians as much peace of mind as they can, so that clinicians would feel like they were not putting themselves in legal or professional jeopardy by making the very hard decisions about allocation of resources, allocation of hospital beds, access to medications like remdesivir. So that's where the initial grant of enormous liability came from. And then the rebound, the boomerang effect, was with the very substantial number of deaths in long-term care facilities in the spring. There was a groundswell demand that first, that the EDTPA be repealed in its entirety. And then when that became obviously not a viable alternative because of the need for some immunity in those difficult ventilator allocation and medication allocation decisions, it became a partial repeal, really just stripping the protection of long-term care facilities in decisions not directly related to COVID treatment. So that was part of what we were up against. The next question, just sort of an open-ended question: do POLST or MOLST forms play a role in this? These are medical orders for life-sustaining treatment. Unfortunately, when you have institutions like long-term care facilities that are torn by their patient care responsibilities and their public health responsibilities, a MOLST is all well and good for knowing what the patient would like you to do or would like you to not do, but that is not going to address the difficulties, both the clinical difficulties and the regulatory challenges that institutions are facing. So while I strongly urge everyone to ask their clinician, physician, or nurse practitioner for a MOLST form or POLST form, that's not going to solve this particular kind of problem. Likewise, none of these laws, this goes to the next question we have, none of these laws really deal with, excuse me, the underlying sort of fundamental right that patients have to make their own decisions. So, we don't have, even in this COVID environment, any law that says that a hospital or a doctor can hold a patient in the hospital and prevent them from leaving AMA, short of 9.27 of the mental hygiene law that I cited, which is the emergency involuntary hospitalization, which only applies if somebody is a danger to themselves or to others. So it really doesn't have a lot of application. Next question is more to you, Carol. It's difficult, the questioner observes, to get medical staff to commit to being present throughout a full course of mediation. And so do you have something like asynchronous mediation meetings? Do you think the Zoom methodology is a help or a hindrance?
So on the question of getting staff present, that's it's always a challenge. Partly because people are really busy, and partly because if you've got an excuse like I'm really busy, so I don't have to go and sit down with people who are mad at me and have been yelling at me, well, I'll take the excuse. I think that the answer is that when programs like Nancy and Tia Powell's up at Montefiore get known, they are seen as valuable assets, and people are most, not all, but a critical mass of the team is willing to spend time. Now, in classic mediation, I will say to people, we can go on as long as you want. We can go into night. We can go on. That's, you know, we don't say that in bioethics mediation. You still have some time limits, and so the mediator has to be a bit more directive in terms of shaping the agenda. But if you do it too much, you're going to lose the family, and they're going to feel pushed rather than being respected. But I think once the program's understood, and once there've been one or two good experiences, the word gets around.
And Carol, what is your feeling about?
Can I just say one thing?
Yep.
We did a demonstration project. Chris Sternheim and I did a demonstration project on mediating medical malpractice cases. Our notion there being that mediation lets people get heard, and often money. You know, the case is about more than money for the families, and they really want some sense of recognition of what's the impact on them and their family, as well as compensation. But we did this demonstration project where we had insurance companies, the hospitals, send us cases they thought would be good for mediation. And then we asked the outside defense counsel and plaintiff's counsel whether they'd be willing to participate. Many more yeses from plaintiff's counsel and defense counsel. And out of the 30 cases that we actually took to mediation, we had absolutely 0 physicians at the table. It was interesting. And it was, I think it made it more costly. I've done cases with physicians or supervisors at the table, and it makes all the difference in the world.
And I think the lesson we have to learn for resolving these kinds of clinical disputes is to not let the physician being the invisible hand become the norm. Because once they get the sense that this is something that lawyers do, or this is something that mediators do with families, I don't have to be involved, that's a problem. So do you have any thoughts about how Zoom can either be a positive or a negative influence doing mediation or problem solving, dispute resolution over video conferencing? Do you sense it's good or bad?
It's what we got. And so I am going to now generalize from a robust data set of one case that I've done with multi-party, and it involved all kinds of really messy interpersonal disputes. It wasn't a healthcare case. It was another setting. I was surprised at how well it worked, and I can't wait to get back to face-to-face. But I think that we will see, even when we can go back to face-to-face, I think we will see much more mix and match, where people don't have, we no longer will require people, everyone. I'd rather have people there. You can't see whether you can't see my great beat up jeans that I have on below this great jacket. You can't see whether I'm twisting my hands, tapping my feet. You can't make eye contact. When I mediated, that was the biggest thing. I realized how much information I get from making eye contact. So, but I think mediators are learning to mediate with Zoom. And it's gone better than most people, when I've talked to my colleagues, is better than most of them expected. But
Yeah.
I still think, and I think there's still a big learning going on, as there is in all other kinds of Zoom communication. But I think it's, it's better than nothing. And if that's the way you can get people together.
I've done several bioethics consultations over the last 6 months over phone or Zoom, and it has some limitations, but I have to say, I think it has some definite advantages in that people are physically remote, and therefore a lot of the body language is not an inflammatory influence. So I think that's a good thing. And frankly, the ability to say, you know what, it's been a long day. We have some information we need to gather to clarify the clinical situation. Let's meet back at the end of the workday again tomorrow. It's not as big an inconvenience, and therefore it's something people are more willing to do. So I would say in that respect, remote dispute resolution, whether it's consultation or mediation, has some real pluses to it.
Yeah. And I think we're learning, and there's been some interesting sharing of information. So I think we'll come out of this with a more robust set of tools to use in any mediation when Zoom isn't the only option. On the on the question of having somebody from in-house be the mediator versus an independent mediator. So when Nancy Dubler and I started working together, I'd say for the first 3 or 4 years, and until we went back and forth on this, I would almost say we had a conflict about this, where I said, you have to have somebody from outside. And she said, it'll never happen. Hospitals are their own little world, their own little community. An outsider will never be accepted. And besides, you're not there when we need you. And we don't have time to call you up and have you adjust your schedule. When in bioethics cases, you need somebody who can be there in an hour or two or the same day. Most often you don't have the luxury of calling a mediator, scheduling it a couple of weeks out. And I think she finally won me over. And as long as the person really is independent, does not see themselves as evaluative, and doesn't see they can be an educator and explain to everybody at the table what the ethical principles are. Mm-hmm. But they can really have to be very careful not to be making recommendations, and they have to be very clear about what that they do work for the institution, that they are not there to make a decision, they're not going to be reporting their views to anyone, and that they had no role in the case and will have no role in the treatment decisions. So Nancy actually convinced me that most of the time it makes it just isn't practical to have somebody from outside. I did do one case where I co-mediated with an insider from a local hospital, where they were really stuck and thought just having somebody from outside with a different perspective and who wasn't a medical person would be helpful, and it sort of helped.
I would say from my experience as an ethics consultant, you have to stay away from the notion that one size fits all and that one is necessarily better or worse. And in the interest of full disclosure, because both Carol and Nancy were my teachers when I was doing my bioethics training 26 years ago, I won't take a position on whether inside or outside mediators are better. I will say from a consultation perspective, sometimes somebody who is familiar and knows the process is going to be able to bring some expertise that's valuable. Other times, the absence of someone who is distanced or detached from the actual clinical circumstance can be the vehicle for people opening up and talking more candidly in a way that you couldn't accomplish if the patient was dealing with someone who had been involved with the course of clinical care. So I think there's a role for both approaches. And the most dangerous thing is to get married to only one approach or only the other, because every patient situation is different.
Yeah, and I think one reason you can be effective is your institutions. You're not being called in as the local mediator who doesn't understand healthcare, the regulatory regime. It's I think what was critical Nancy and my debate was you need to have credibility with the people who are going to be at the table, and you need to understand the context, the culture, both the medical culture, the regulatory culture. So I think it's those kind of things that you want to look for. And I don't think you can just say this person's a good communicator, you're the mediator. I think they need to be trained. I think we used people with Nancy, who worked with Tia, people in Tia's service now. The people I work with most closely have all gone through mediation training, and then they do a kind of mix of whatever seems to work. I mean, whatever seems to work, but I think you need the tools.
So next we have a fascinating question that sort of is a natural extension of this discussion. Can a savvy participant, and as in the example of the 14-year-old who summarized her mother's concerns and her own, take the place of a mediator, in effect, self-mediation? And are there things that a mediator can do that a participant in a conflict cannot?
So I teach negotiation as well. And when I first started teaching negotiation, I thought, I'm going to put the other half of me out of business, because if we teach everyone to be great negotiators, we'll never need mediators. But there's been a lot of wonderful research on kind of the social psychology of people in conflict, and I think there are times where you want to, things like reactive devaluation. David and I are having an argument. David makes a proposal. It's just what I was thinking. Do I say, oh, David, great idea, we got a deal? I think, wait a minute, he came up with it, he's my enemy, it must be better for him than for me. No, I won't do that.
Or I should ask for more.
Yeah, or I should ask, exactly. If that's what, then I'm missing something.
Yep.
So there are framing things. If you frame things as a gain, if I see something as a gain for me, I'm more likely to say yes than if I see it as a loss. So my classic example, this is going to really date me, but when my son was a teenager and we had a landline, one landline, I don't know if anybody's here is old enough to remember that, and we'd have, at night, we'd have some disputes about access to the telephone. And so there would be a mediator can say, Mrs. Liebman, what if your son, I won't just say which son, what if your son gave you the phone for the last 10 minutes of every hour and guaranteed that that was your 10 minutes? And what if, kid, what if your mom lets you have the phone for the first 50 minutes of every hour? That's different. It's different than I'm like you say, you got to give me the phone. You've got to get off the phone for those 10 minutes. It feels like a loss. And so I think through those kinds of techniques, cutting off the kind of reactive devaluation, there's a whole wonderful literature of all of this, but there are places where mediators can get in the midst of these psychological phenomena that can make people make bad decisions for themselves. So I
think in answer to the question, there are times when negotiation is adequate and maybe even best. And we typically try negotiation. Negotiation is a natural part of our social construct. It's when negotiation doesn't work, just as sometimes when a bioethics consultation doesn't work, we will turn to mediation or something that rests between a consultation and a mediation. So I think the answer is mediation is there when all of your other techniques haven't worked. So our next question, how resistant are long-term care facilities to mediation if the admission agreement includes an arbitration clause, and are there facilities likely to agree to mediation before arbitration? So interesting, the arbitration clauses.
Why don't you change those agreements and change the.
So I've actually written some on the use of pre-dispute binding arbitration, and I think it has a place, but it doesn't have a place in the kind of clinical disputes that we're talking about tonight. And I don't think the fact that there's an arbitration clause in a residency agreement affects how we ought to be dealing with these very novel, really clinically oriented and socially oriented disputes, because unlike financial disputes or liability disputes that are typically the purpose of mandatory arbitration or mediation clauses, these are circumstances that nobody anticipated. I can tell you, even having been involved in the sort of post hoc analysis of the last round of pandemics, avian flu and swine flu, I did not foresee that we would be having this kind of discussion today about the positive and negative implications of the Emergency or Disaster Treatment Protection Act and all of the influences of giving clinicians and facilities what is, let's face it, a get out of jail free card was going to have as a negative consequence. But mediation is still the best technique for getting the resident or their family and the institution or the provider to be able to talk with each other rather than at each other. And I don't see a better way, and I will continue to advocate for use of mediation for the most difficult disputes we face, even when it's possible to insist on arbitration. They're just different kinds of disputes.
You know, it answers the question about, can you mediate for yourself? Do you need a mediator? Since most of the time you're not going to get a mediator in these disputes, in addition to remember interest feelings, summarize, my colleague taken over the mediation clinic at Columbia, Alex Carter, has a wonderful book out called Ask for More. And she talks about when you're in a difficult conversation, in a negotiation, 5 questions you should ask yourself and 5 questions you should ask the other person. And I think it's a really it would be a very useful tool for many of you who are having to do the frontline conversations.
Absolutely. So an interesting question that takes us again out of our clinical context: can these kinds of techniques that we've been talking about be helpful in the broader political divide in our country? And what lessons can we learn about healing the disputes in our political discourse from our discussion tonight of resolving these disputes between families and practitioners? You know, it ought to work. I think the techniques are as valid in a political discussion as in a clinical discussion. The hard part is getting people in the same room or in the same conversation. And that's a problem that we're going to have to confront as a nation.
Yeah, I think we have to do it. I think it can. I think we need to try to identify some of the specific issues so we have differences and start to have conversations about them. But I think about Senator Mitchell's book about the Northern Ireland
Accords, right?
Accords and the months and days and years and what was that? How many years? 600 years, I think it was. But yeah. People have to be at a point where they realize that there's got to be something better, and I think we just have to keep the doors open. And interesting watching my own reaction. For the last 6 months, I didn't even want to think about understanding. I was just so wrought. But I think it's really hard, and I think people are getting enough trust that it's going to be safe. It's going to be very hard, and it means it means both being respectful and making gestures, but also not being taken for a sucker. Sort of not. That doesn't mean not standing up for what you believe, but finding a way to do it in a way that isn't destructive. But it's very hard. My college class has occasional Zoom meetings, and somebody said we should have our next meeting talk about how we can bridge the gaps. And wow, we're not going to do it. All I can say is we're not going to do it. People were really resistant and well, I don't want to be attacked. And
right. I have to tell you, one of the lessons I've learned from my clinical consultation practice is take all the time you need if time is available. So what the timing should be for resolving one of the disputes we've been talking about tonight, or the larger political divide, depends upon how important urgency is in the discussion. So if I have a family that is amenable to leaving mama in the long-term care facility for another night so we can try to come up with a better solution, so be it. And if there isn't time, you have to convey that there is a time urgency that is beyond all of our control, because if you step foot outside that door, coming back through is not going to be available as an option. Yeah. So we have one more question. Have we been using our clergy and chaplains to serve as mediators? They can be an excellent resource. So they can absolutely be an excellent resource. That's a separate and interesting question from whether they can serve as mediators. Carol, do you have any thoughts on that?
I think, if they've been trained as mediators, absolutely. I did a training once at a conference. I was at a conference for clergy, interdenominational conference of clergy, and did a introduction to mediation, and we did a role play. And what I love about this is when I've done trainings for psychiatrists, for lawyers, chaplains, physicians, everybody starts from their own professional base with their own professional skills, which are both assets and sometimes liabilities. And some of the chaplains had just as much trouble as some of the lawyers because of this drive to make it better. So I think that giving up control, I mean, when I come out of mediation, people will say, I don't know what you did, but you did something. And I think, yeah, that's the best mediation. I know I did it. They think they did it. That's the best. But yes, I think certainly chaplains have a skill set that is very close. And they are certainly on a lot of ethics committees, and I've trained chaplains to be bioethics mediators. And I think they're often, they often get it quickest and fastest. So it's certainly an asset.
Yeah, I think they,
well, go ahead. I just wanted to say something about masks.
Yeah,
I had some tips about the mask issue before I don't want to leave.
Yeah, we have a few minutes. We're going to get to that. I think they occupy that really interesting position that we were talking about earlier of somebody who's inside the institution, but is viewed as being somewhat at arm's length. And you can talk to a chaplain, even in a non-theologic way, about frustrations you have with the facility, whether you are a patient or a provider, and that's a valuable role. So I think we have work to do there.
And I think the notion of interest and the kind of spiritual interest, are things that chaplains are often much more comfortable talking with families and patients about than other more treatment-oriented members of the team.
Yep. So we were prepared with a couple of other hypotheticals in case there were no questions. Thank you all for supplying some really excellent questions. But we did want to talk about a circumstance that I've been confronting and my colleagues have been confronting in long-term care and acute care facilities. And that is people showing up at a facility refusing to wear a mask, which is a precondition to get in the front door, or taking it off once they get inside. And this is a real dilemma, and one that I have not found terribly effective techniques for dealing with, other than that very authoritative lawyer approach that we were talking about a few minutes ago.
So I was thinking about this, and a couple of things. I mean, one thing, the first intervention you can do is just point at the mask or hand somebody a mask without saying anything. So not, or just say, I see that, you're not wearing a mask, here. Could you pull your mask up all the way, please? I know it's uncomfortable, but, but I think not seeming to judge, but I actually, very interesting, Columbia Facilities has a lot of responsibility for making sure people are complying. And they have a matrix called FIRR, F-I-R-R, that I thought might be useful. So the way they're trained is to state the facts. I see you're not wearing a mask. The impact, yeah, that can put other people at risk of infection. Even if you feel fine, you might be carrying, and it can also put you at greater risk if somebody here is infected and doesn't know it. You know, the disease spreads through drops that are spread by talking, coughing, laughing, breathing. I know you don't want to intentionally, you know, sort of the reason and acknowledgement, you're not a bad person. Yeah, I know you don't want to put your mom or your dad or anybody else at risk. And masks are the best way to deal with it. And then a request, you know. So I know it's not pleasant. I know people don't like to be told they have to do this, but, you know, would you please, while you're here, wear a mask?
It is one of many challenges we face. So we're just about.
Can I just say,
yeah,
it doesn't always work. I was telling David, I went to an eye surgeon for a laser procedure, and I had to tell him 4 different times to pull the mask up all the time. And needless to say, I didn't have enough presence to walk out, which I should have in the midst, but I have not been back and will not be back to see him. So it doesn't always work, even when you're a pro.
Yeah, no, there are many challenges. I think everyone who's participating tonight understands that we have barely scratched the surface on the challenges we face. You should know that we in the Columbia Bioethics program are committed to finding solutions to these problems. Tonight's program is one example, but there are many others. If you're interested in dealing with these questions and these challenges in greater detail, I invite you to come to the Columbia Bioethics website to look at our pre-recorded programs, to look at our course offerings, our Voices in Bioethics online bioethics journal, which is open to the public, and to stay engaged with this community, because these are important conversations. So I'll leave you with tonight's second CLE participation code, which is CARE. So you have the first code, and the second code is its companion, CARE, and we will be circulating the CLE forms for anyone who wants CLE credit. And I'm pleased to report that this program will be available for CLE credit on our website after we get this program downloaded and posted, so that anyone you know who was interested in this topic and who needs CLE credit can view the program online and get CLE credit for their participation. With that, I'm going to say thank you. I'm really glad that we got to have this discussion. I'm glad that we will be able to continue the discussion moving forward, because these are, I can tell you from a clinician's perspective, very serious problems that are not going away anytime soon. Good night.